Good morning, Chief Justice and Associate Justices. May it please the Court. My name is Penny Dean, and I represent Jay Simkin, who's the appellant in this matter. And this matter, quite frankly, is about rule of law. On one side is my client, a federally licensed firearms dealer with a blemishless record. He's been licensed by the federal authorities for about 30 years to transact in all types of firearms, including machine guns, with a duty to protect his inventory every day. My client has neither broken nor infringed any law or regulation relating to the use of his Class A unrestricted license to carry, and there's even been no accusation by the Commonwealth that he's broken any law or regulation. And this appears to be a case of first impression, and I'm dismayed to be acting on such an entirely law-abiding client who's been needlessly victimized under color of law. There's no basis in law or fact for any action taken against my client, let alone the extreme action of revocation by a licensor.
Well, would you agree that his behavior was unusual?
Unusual by some standards, maybe. It depends on what you're used to, with all due respect, Your Honor. Not all people have the financial ability to pay for their own medical services. So most people will use their health insurance if they have it. So that is, people who pay privately for insurance or for coverage is unusual. Yes, Your Honor, I agree.
And to use a pseudonym, an alias?
Well, a pseudonym is not that unusual, I respectfully say, Your Honor. Here's what I would respectfully state to this Court. Had they not called the police late that evening, about 8:36 that evening, the record shows, I don't believe to this day that they would know that Mr. Simkin used a pseudonym there. Because up to that point, they didn't know he used or the record shows up to that point, no one knows he used a pseudonym. And they didn't know he had until they went and checked on him. And given the medical privacy, Your Honor, medical privacy issues, he had reasonable concern. We hear stories every day where medical facilities and even courts, if you will, with all due respect, sometimes people leave laptops and things are just not as secure as one would hope.
Well, let me just press the point to the next step.
Yes, Your Honor.
Is it at least a little unusual to show up at a doctor's office with a couple of guns and some knives strapped
Not
to
for
you?
people who carry firearms every day. I checked 2 firearms and stuff at the court down there when I checked in today. People who carry firearms every day of their life carry at least one. The rule is 1 gun, no gun, 2 guns, 1 gun, 3 gun, 2 gun. It's because it's just like I carry a full-size spare tire in my truck because tires sometimes go flat. I had a brand new.
Excuse me, what is the rule?
1 gun, no gun, 2 guns, 1 gun, 3 gun, 2 gun. And basically what it's saying is that firearms are mechanical objects. Mechanical objects can and do break. I cited a whole slew of cases for this court in our brief whereby criminals, now these happen to be criminals that you had before the court, their firearms malfunctioned while committing criminal acts. Firearms are mechanical objects. They fail all the time. They can and do fail. And anybody who believes that they may need a firearm for self-defense, who thinks that a firearm is never going to break, a mag's never going to jam, a primer's never going to misfire, is just plain silly. It just, you're betting your life that that object is going to work perfectly. I just don't think that's reality. Well, I know it's not reality. You can see a whole slew of cases where the criminals didn't plan on their gun jamming at that point. From what I could read of those cases, they planned on those firearms working just fine. And fortunately for the law-abiding, their firearms jammed or misfired.
Can I go back to the pseudonym
Yes.
issue? He used the same pseudonym for both appointments, correct?
He absolutely did, because the first appointment, they didn't ask him for any information. The second appointment, because he was an established patient.
Okay. So they didn't ask him for any information the second appointment?
The record shows that he wasn't asked for, because they had a name, address, phone number,
The information they needed.
Right.
All right. And there was no insurance here. There was nothing that would require accurate identification of the individual.
Right. And this isn't a case where he tried to commit insurance fraud. He paid in cash for his services.
Now, you said that there was a call made at 8:36. What call are we talking about here?
The record shows at approximately 8:36 p.m., Mary Bushy, who was one of the employees of the medical practice, called the Stoneham PD And what specifically was said, we don't know. I was never able to get an audio tape, so I can just tell you what appears in the record, and I'm going to paraphrase. That basically this person carried a firearm, and they were concerned and wanted to know if he was legal carrying firearms.
Now, okay, so that was at 8, when was? his
8:36
appointment?
p.m.
When was his appointment?
I believe the record shows 1 o'clock, approximately 1 p.m. that day. And again, I'm talking rough numbers.
All right, so 6 or 7 hours after the appointment, there's a call to the police station.
Right.
This person had a firearm.
Right. And the record shows that he had been at the facility the first time, approximately a month earlier, had firearms then. They didn't call after that visit. The record also shows that they had said they had had other visitors over the years that carried firearms. I believe they had been law enforcement visitors, the record showed. And it wasn't perfectly crystal clear on that. And our argument is, in sense in this case, is that idle gossip started this. And they didn't call 911. They didn't, this is a huge medical facility with lots of phones. People have cell phones. Nobody called 911. And the person that called did not see or have contact with Mr. Simkin, according to the record. And I think that's notable. What's also notable, and I think very important for this court to understand, is the senior doctor who appears to be in charge or own, I'm not sure which, the facility, has said Mr. Simkin is welcome back at that facility. Mr. Simkin has not been, and as a matter of fact, was outraged. In other words, we had people interview those people, and what was really, quite frankly, troubling to me is that no one called Mr. Simkin from the Firearms Record Bureau. When I called the Firearms Record Bureau to try and talk to them, I was given with a flamethrower. There was nobody wanted to talk to me. No one wanted to hear Mr. Simkin's side of the story. This man wasn't offered a hearing. He wasn't offered to give an explanation. His license was summarily revoked. There's no due process. There was no process. And what was worse in this particular case is neither Stoneham Police or FRB bothered to speak to one person who had any real contact with Mr. Simkin. The only person, according to the record, Jennifer, saw the firearms. They didn't bother to interview her. Never once. I finally sent a private investigator in April to interview all these people. We have interviews. They're part of the record. And each person was asked, did you ever see Mr. Simkin or his firearms? Nobody did except for Jennifer, and the second-in-command doctor saw a knife.
So let's assume you prevail. What's the rule, then, in the future in situations where any institution is confronted with a person who uses a phony name, who carries a bunch of guns, and who is paying with cash? The payment with cash, isn't that one of the triggering things in terms of the airplane people who buy their tickets and pay cash that raises red flags? What are they to do?
Well, first of all, they're a private facility. They could have asked Mr. Simkin to leave, and he would have left. The record shows if they would have said, Mr. Simkin, we don't want your money and your business here, like any private facility, they have a right to refuse service to anyone they choose. If I go to Costco and they say, we don't like blonde women here, as long as they don't discriminate against blacks, Hispanics, or whatever, they can say they don't like women with red hair. That private facility has a right to say, Mr. Simkin, we don't want you or your money here. They didn't do that. He's still welcome there.
But a lot of people have red hair, and they walk into Costco with red hair or blonde hair or whatever kind of hair, and sometimes no hair. But is it a common occurrence for somebody to walk into Costco with gun magazines and guns strapped to them and carrying four knives?
A whole pile of them. A whole pile of them. You just don't know about.
When these people confront one another, is there some concern that there's going to be a shootout or anything like that?
Absolutely not. That's absolutely fallacious. I can tell you right now that firearm owning people are the most peaceful people you'll ever see, because you have to walk away from an altercation, because if not, you're going to get accused of accelerating and get accused that you were doing it because you had a gun. Here's what I tell people, is that if you're in line at the post office, or not the post office, at a grocery store, and someone cuts ahead of me, I say, oh, I'm very sorry, go right ahead, sir. Even though the guy cut right in front of me and I was there, because you never want to be accused of escalating or starting anything, because they're going to say you're that type of person because you have a gun. So what you have to do is be nicer than average. You have to be nicer in traffic. You have to just, not only that, quite frankly, I'm terrified of having to go before the judicial system if I ever have to use my firearm. So no, I stay no trouble. Just as Mr. Simkin said, he would have left that medical practice. But I think, to your point, Justice, is the Firearms Record Bureau has the power, they have the right to restrict any license any way they want, and they sometimes do. He had a Class A unrestricted license since 2002. When they issued his license, they could have said in Alaska you have to qualify by calibers. You used to, not today. And they would say only 45 caliber or above, only 22 caliber or whatever. They could have restricted that license in any way they wanted. They didn't do so.
Can I ask you this question?
Yes, Justice.
I understand your argument that 131F you have to look at totally independently from 130. So, but my question, I guess, is if you do that, how procedurally are you suggesting that once somebody gets a temporary license to carry, there is no way to revoke it?
No, I am not. No, I'm not. They have a whole list of disqualifiers in 131F. A whole statutory list.
No procedure for, there's no mention about revoking, is there?
No, there is not.
So how do you do it?
Real simple. And I don't mean to be a smart aleck, but let me answer it this way, okay? If you cannot lawfully own a gun, you can't carry a gun. It's that simple.
I understand that.
And so they have a whole list of statutory disqualifiers. So if you become disqualified in any of those areas, you can't carry a gun even if you have the license, and I think it becomes void by operation of law because of the fact that you are statutorily disqualified then. You know, there's a whole list of those. But here's the thing that you have to look at. My client shouldn't be a mind reader, or she shouldn't be punished because the FRB was too darn lazy, and I'm sorry to say this, too darn lazy to write any administrative regulations. If you look at a whole...
Regulations would you suggest that they should have written?
I don't suggest they should have written any, but if they want to...
Their authority to write regulations about this if there's no provision for it in the statute.
There absolutely is provision in the statute. State police can write any regulations. FRB could adopt any regulations that they want pertaining to issuance of licenses to carry. They haven't done so. They could have offered...
They don't have to write a regulation to revoke a permit, do they?
If it doesn't provide...
The statute says that they can.
The statute doesn't say anything about revocation, Justice, with all due respect.
Nowhere.
Not anywhere
not
that...
in 131F.
No, not in
No,
131F.
but let's get over that for a second. But certainly 131 provides for revocation.
131 provides for revocation, but with all due respect to the court, I don't believe that 131 applies. And if you look at the legislation...
Right, let's get beyond that for a moment.
Yes.
Okay. That's a legal argument, and that's a statutory construction argument. I'm just...
Right. If it applies, you can't pick and choose which parts of 131 you want to pick. It has to be the way it's written, all or nothing. And if that's the case, then they've been issuing licenses illegally for 4 or 5 years, and that's a serious argument because just because you want to ignore parts of the statute or, gee, we didn't know this applied to us, doesn't mean that they're not held to the law just like the rest of us.
Now, explain again to me why you say they've been illegally issuing licenses. Because they're the wrong size?
Because they're the wrong size and type. And you might maybe scoff and say, well, that's just plain silly. But here's what I say with all due respect to the court, is the legislature passes a law. And if it's illegal or repugnant to the Constitution, certainly under separation of powers, this court has the right to make the appropriate rulings. However, this is a ministerial function that the ministerial mechanical function of how the office is supposed to issue licenses that the legislature, I would argue, certainly has the right to mandate. And they did mandate, and they mandated it very clearly by size and shape. And if we're going to go down what I call your road, with all due respect, the 131F road, there's something else that absolutely should have happened. When Mr. Simkin's license was revoked, the way it happens with everyone there, is all of his firearms should have been seized. In other words, because your license is revoked, your firearms are seized.
But he's not in Massachusetts when it's revoked. He's up in New Hampshire.
Right, he's a New Hampshire resident, but there's a larger issue. In addition to the fact that he's in New Hampshire, he has machine guns and stuff that none of you people have licenses to take. You can't, you're in violation of federal law. The FRB doesn't have the appropriate license. okay? And he would be in violation for giving them to you even if you had a court order. He would be in a Hobson's choice situation. And so, with all due respect, if you look at the legislative history, it's clear as a bell. It's clear in this, oh my God, my time is up. I apologize.
Quite all right.
Yeah. It's clear as a bell that non-residents and residents were to be treated differently for the reasons in my brief. And thank you.
Thank you very much.
Good morning, Your Honors, or afternoon, as the case may be. David Marks, Assistant
Good morning.
Attorney General.
You're right.
Still morning, for the Firearms Records Bureau. I want to cover the first issue of whether 131F itself provides for a suitability determination as quickly as possible, so we can have a little time to discuss the factual scenario, unless you interrupt me. The Firearms Records Bureau reasonably construed sections 131 and 131F to apply a suitability requirement to the question of whether a non-resident license to carry should be issued under 131F.
You say it did that. It doesn't. Does it do it in regulations, or you mean this opinion?
It does it it does it in its normal, regular, everyday practice.
So this letter here that they sent, the revocation letter.
Yes, the revocation letter reflects that in issuing the license in the first place, the Firearms Records Bureau does a suitability determination.
Whether, this is beside the point, but wouldn't it be helpful to have regulations or something explaining what their procedures are?
Well, there are plenty of.
I mean, with respect to out-of-state temporary license holders?
Well, they issue instructions, if you will, when they. I have a copy here actually. When someone applies for a non-resident license to carry, they have a package of materials that tells the applicant what the procedure is. There's an application form. It tells the applicant what the questions are, what they have to answer, and Section 131 itself is a comprehensive licensing scheme. And Section
Referenced in those materials? Is 131 referenced in those materials?
I think 131 is referenced in these materials, but
Is this in the record, by the way, what you're holding here? The application is?
I think these materials
Ms. Dean says it is.
Ms. Dean says
Yes.
that they are in the.
I don't know where they are.
I can't tell you right now what page, but I believe the latest version of this is in the materials. But 131 itself provides a comprehensive licensing scheme. There's no question that that the last sentence of Section 131 does give the Secretary of the Executive Office of Public Safety the authority to promulgate regulations. It doesn't require the Secretary to do that, but Section 131 does say the Secretary may promulgate regulations.
Can I ask you, when when the FRB decides that someone's no longer suitable, it's troubling, I think, that there's no hearing or no opportunity for the person who has the license to be heard. I mean, it could be on absolutely false information presented to the FRB that the determination is being made, and it could have an impact on someone who really may, for very good reasons, need the firearm. There's no provision for a hearing, some process. That's.
Oh, there is provision for a hearing and process.
Well, yeah, but that's
in the district
in the
court.
district court.
That's right. 131 sets forth the provisions for revocation, non-renewal of licenses, and it specifically provides for a right to judicial review in the district court. And the case law has said that that right of judicial review includes an evidentiary hearing.
So the findings get made by the district court judge.
Well, the licensing authority.
Factual findings get made by the district court judge.
That's right.
And
Ultimately,
then
that's
the
right.
question that was raised in one of the briefs has to do with, well, then when it goes on to Superior Court, is the Superior Court judge in a position to make different fact findings?
No.
They have to accept the fact findings of the district court judge.
It's on a certiorari review.
It's on certiorari review. Yeah, so the record before the district court is the record that is under review in Superior Court.
Yeah, and the Superior Court judge is not free to sort of reach different factual determinations.
Correct. Now, the record here is relatively clear in the sense that there really is no, despite what it sounds like from Ms. Dean, there really is no dispute as to the facts, as to what happened. There may be, and there's a lot of, dispute about how you characterize those facts. Did Mr. Simkin use a pseudonym versus a false name? Well, he used a name that was not his name.
So what?
What's
what?
illegal about that?
They're not saying anything's illegal.
Nothing he did was illegal
Or fraudulent in any way?
or fraudulent in any way that we're aware of. Nothing.
Nothing violated any regulation that you might have promulgated regarding suitability?
That's correct. There's no. It doesn't appear that you violated a regulation.
Or anything, any
However,
disqualifiers in the statute?
that's correct. He didn't violate he was not statutorily disqualified.
And is it illegal to, for instance, go into a supermarket to buy your groceries and have weapons strapped all around you?
Not if you're licensed.
If you're licensed, it's okay.
He had a license to carry a concealed, large capacity, semi-automatic handgun.
And it might alarm people in a grocery store if someone came in with such weapons, but is that a basis to say he's not suitable?
Here, it is the intersection of all of the facts and circumstances that gave the Firearms Records Bureau a reasonable basis to say he was no longer a responsible person to be entrusted with firearms.
So 0 plus 0 plus 0 equals 1?
Well, no. Let me count for you.
Well, let me ask you this. If he had paid for his medical bill in his own name, and if he had submitted insurance instead of cash or a credit card, would that have been okay?
I think let's look at all the circumstances. Keep in mind, the case law is clear. One does not have to commit a crime or be convicted of a crime to be found no longer suitable.
Was there any evidence that he was mentally ill?
There is no indication in the record that any health professional has found him mentally ill. This is what happened. He came to a medical office on 2 occasions. He had at least 2 firearms. He had multiple magazines of ammunition. He had several knives. On each of those occasions, he showed the weapons to at least 1, if not 2, staff members at the medical practice.
For what purpose? For what purpose? Did he twirl the guns and sort of say, I'm loaded?
As far as the record reflects, he just showed them
And put them in the
briefcase. And he locked the briefcase. That's right.
And he did that on 2 separate occasions.
Correct. He did that on 2 separate occasions.
This is
This
is a visit for urology. I assume he had to strip.
It appears he had to take his clothes off.
So is that what is wrong with essentially warning people that I'm going to strip and therefore you're going to see guns? And
Because presumably he might have been in a private room when he was disrobing, but I don't know.
Let's look at all of the facts and circumstances because that's what the Firearms Records Bureau did. He also paid in cash on both occasions. He gave very minimal identifying information. He gave a false name. He gave a false address. I believe he also gave a date of birth. That's it. And he caused concern and alarm to those people.
To one person who called.
7 hours later?
The record, this is in his own investigators' interviews of the witnesses. It appears that more than one person was concerned and alarmed, but the only person who saw his weapons, there were 3 people who saw his weapons. One of them, you're right, expressed
And wanted to
concern
know
and
if he was
alarm.
licensed. And he is.
Now, here's the problem. By showing his weapons to them, he made them witnesses to his conduct under the authority of the license. And it should come as no surprise to Mr. Simkin that the Firearms Records Bureau would take a dim view of his use of a false name and a false address. Why? Because Section 129 of Chapter 140 makes it a crime to use a false name or a false address on an application for a license. The Hightower decision
But
out
he
of the
didn't
First
use
Circuit.
a false name on his application,
That's
did he?
true. The point, though, is, and the Hightower decision emphasizes this as well, whether someone gives false information or not is important to the licensing authority. And here, where he uses a false name and a false address, at the same time that he asserts his rights under the authority of the license, he undermines the ability of both the witnesses and the police and the licensing authority to determine, one, whether he is licensed to carry the firearms, and two, whether he is misbehaving in some other way that would cause the licensing authority to have concerns about whether he should continue to be licensed. Now, just because, ultimately, the police were able to figure out who he was in reality, and it was not easy, and the record reflects that in the police
It took
report.
Mr. Simkin to tell them, as I read it. In other words,
I'm sorry?
the first, is that right? In other words, when they finally found the person in Maryland, the Maryland person said, "I will have him contact you." So then Mr. Simkin contacted them. Is that right?
Well, he said, I will have him, this is a pseudonym a friend of mine uses, I'll have him contact you. He lives in Nashua, New Hampshire. The next thing that happened is a lawyer from Woburn called the Stoneham police and said, I hear you're asking about a client of mine. What do you want to know about him? Okay, I'll have him contact you. And then Mr. Simkin emailed the detective at the police department. And that was the contact Mr. Simkin had with the police department. My point is, at any point along the way, he could have put up a roadblock and prevented the licensing authority from investigating his behavior vis-a-vis the weapons.
Is there a regulation that prohibits him from doing that?
From doing,
A published regulation from the Firearms Record Bureau that prevents him from using a false name in public?
no, no.
So it
And I'm-
can't be of much concern to the Firearms Bureau.
the myriad of ways someone could be not suitable to continue to have a license to carry firearms does not lend itself to canonization in a regulation. That is the problem here. There is no requirement that the definition of suitability or what steps a licensing authority will take in order to determine whether someone is or isn't suitable. There is no requirement that that be enshrined in regulations.
But the opposite of that, of course, is some version of void for vagueness. I mean, what's suitable to your suitable is not mine. I mean, it's just very hard if you're the licensee to know what you're supposed to be doing.
Well, however, cases have upheld the firearms laws on
fact.
void for vagueness challenges. Keep in mind that the statutory scheme, this is Section 131, provides that these suitability determinations are made by the local licensing authorities,
But
local
that isn't
police
this case,
chiefs.
because we don't have a local licensing authority making it, do we?
That's right. But the point is that suitability and the test for suitability is applied by a large number of individuals who have the right to apply that test, and those individuals may not necessarily be subject to regulations. Moreover, it is the
But they can't behave in an arbitrary and capricious fashion.
You're right. And that's what the district court review is all about. If the discretion of the licensing authority is exercised in an arbitrary way, the district court overturns it.
Well, let me ask you
happens-
this. Oh, well, I'm
Go
sorry.
ahead.
The district court, in fact, did overturn it.
Correct.
And found it to be arbitrary and capricious.
Correct.
So what's the so I want to ask you, her findings, though, Judge McLeod said, no,
Yes, Judge McLeod said the district court applied the wrong test. The district court did not, one, defer to the wide discretion of the licensing authority, and two, did not ask whether there is a reasonable basis for the licensing authority's decision here. And that's what the case law says. In order to determine whether the licensing authority has abused his or her discretion in revoking a license on the suitability basis, the question is, did the licensing authority have a reasonable basis?
Well, I thought that's what she was getting at, though. The fact that someone would be alarmed seeing someone with guns is not a reasonable basis, because that happens. Some people are very anxious around guns, but the person has a license to carry guns. So that's not a reasonable basis. It's certainly not a reasonable basis because he was wearing guns, because he had an unrestricted license to carry them. So that wasn't a reasonable basis. So it has to come down to your last thing, the giving a false name to a doctor or a pseudonym to a doctor because he doesn't want his privacy invaded. He doesn't want the information to get out into the world as to he's got a problem.
In the context of his use
It's not in the
of
context
guns.
of anything. It's in the context of his being at a doctor's office.
Well, no, he showed them the weapons.
Well,
As soon as he showed them the weapons,
If he's wearing the weapons and he's going to take his clothes off, how's he not going to show them his weapons?
hide them? Would it be a problem if he hid and concealed the weapons and didn't tell the people there or someone there that he actually had weapons in this suitcase that he was putting them in, locking?
I hate to do this because it's not on the record, but every time I go to the doctors leave me alone in the examination room to get undressed.
And if you
He
had a
didn't
couple
have to. He didn't have to do it. He could have gotten undressed, put his weapons in the briefcase, and be done with
But
it.
he
He went out of his way to show them.
But just as when you're in a place of public accommodation, that people want to know that run those places whether or not you've got weapons. So if you have them, I think they would feel they're better off knowing you have them than if not, because if something happens and all of a sudden somebody comes upon this weapon, that's not a good thing.
Viewing each piece in isolation is not helpful. It is the exhibiting the weapons in relation to the use of the false name and the false address. That is the real problem here. And that is what made it, for the Firearms Records Bureau, reasonable to determine that he was not being responsible. Because ultimately, even if it wasn't his intent, ultimately it operated so as to undermine their ability to police people's use of firearms licenses. And that's why there was a reasonable basis for the Firearm Records Bureau decision.
Does the record reflect whether or not the fact that he was a federally licensed firearms dealer was considered by the board before it acted?
I think the Firearms Records Bureau knew that, but it tells us nothing about how to cast the set of circumstances here. It sheds no light on what happened here. It still doesn't undermine the problem that in the context of his activity under the authority of the license, he used a false name and address. He brought it into a medical practice which was inconsistent with his business purpose of having the license. He caused alarm to people. He knew it would. And all of those facts and circumstances are not undermined, if you will, by the fact that he's a federally licensed firearms dealer.
Mr. Marks, we'll have to leave it there.
Thank you, Your
very
Honors.
much.
I rest on my brief.
All right. Hear ye, hear ye, hear ye.